Brennan's family, especially his father, who on the day of the accident came out of the house and approached a neighbor who was on the phone calling 911 to report the discovery of a human being lying on the shoulder of the road. Mr. Lovelace walked up to see what was happening, and he sees that it is his own 13-year-old son, Brennan, who had just gotten his bicycle for Christmas and had been out riding it in the neighborhood. He calls out to Brennan, who cannot respond. I can only imagine the heartache Brennan's family will feel forever, for the rest of your lives. Your family will always have a hole in your hearts as a result of this terrible, terrible accident. The proposed disposition of a plea to a reduced charge with 1 1/3 to 4 years on each plea to be served concurrently was on the outer edge of what I was willing to go along with as a sentence. But if it had spared the family further pain by having to go through a trial, reliving Brennan's death during the trial, and gave them some closure, I understood. By Mr. Law's own actions, the police lacked the information to find out what really happened to Brennan that day. There was no opportunity to determine whether Mr. Law was impaired in some way that day, why he left the scene and drove away when he knew he had struck someone or something. And then Mr. Law took affirmative steps to cover up his crime by staging an accident 12 hours later, but he didn't fool the police because the forensic evidence that was left behind on Route 7 told the tale. The car parts matched. The damage was not consistent with that staged accident the next day. And Mr. Law, you couldn't even keep that story straight. You said first you hit a deer the next day, then you fell asleep at the wheel. And when Mr. Law was interviewed about what happened to Brennan, he continued to lie to the police, continued to deny that he was even on Route 7 that afternoon. He refused to take any responsibilities for his actions. When he realizes he is going to be charged, that's when he starts saying things like, the person was all in black and in the middle of the road and he couldn't avoid him. Maybe that was true, but it in no way excuses your callous disregard for Brennan's life, where after you struck him with your employer's pickup truck, you apparently dragged Brennan along the road and then left him behind to die. I thought about Brennan's last seconds on Earth, as I'm sure his family does every night when they close their eyes to go to sleep. I only hope that he did not suffer any conscious injuries. Something I found significant in Mr. Law's questionnaire he filled out for probation is in his statement. Quote, I feel remorseful for what happened and wish I could change it. For what happened, not what I did. You don't take responsibility for this terrible event. You sit here now saying that, but in fact you have a new version. And as you just mentioned, and I note on page 11 of the pre-sentence investigation report, you say, I did stop. I opened my door, and on the running board, I looked around, but I couldn't see anything because it was so foggy. And you give a statement to the probation officer about seeing a bear in the area a few days. So you thought maybe that's what you hit. Bears are black, or maybe a cow or something. That's what you told the PO. So this is a new version. This is another version. Because of course you've maintained to the police that you were never even on the road, had no involvement in Brennan's death. But the other evidence from the neighbors that you sped away after striking Brennan with the truck, the statements you made to the police initially, even denying you were on the road that night, just showed that you don't accept that you struck a human being, a child who was out riding his bike, and that you left him to die in the road without a thought to stop or even see what you hit. You only thought of yourself, and you still only think of yourself. In the statement in the questionnaire, you also state, quote, I want to move forward and make a better life for me and my 8-year-old daughter. She's all I have. That's what you're saying. Well, at least you still have a daughter. When you're released from custody, you'll still be able to see your daughter. Brennan's family will never again hear his voice, see his face, or see him grow up to be whatever he wanted to be. So, Mr. Law, on your plea to attempted leaving the scene of a fatal motor vehicle accident, a Class E felony, to reduce charge under the first count of the indictment, it is the sentence of the court, and you are hereby sentenced to an indeterminate term of imprisonment with a maximum of 4 years and a minimum of 1 1/3 years. I note the district attorney did not ask for restitution as part of the negotiated disposition in the form of the funeral expenses for Brennan. I'm required to impose a fine. I'm imposing a $1,000 fine as provided under the Class E felony under Vehicle and Traffic Law Section 600 2C1. I suspended your privilege to drive when you were released on bail in January. I am required now to revoke your driving privilege under Vehicle and Traffic Law 510-2A. It appears from my research on the law, the revocation period under the law for this offense is only 6 months. You have to reapply to get your privileges to drive upon your release. On your plea to criminal possession of a firearm, Class E felony, under the second count of the indictment, it is the sentence of the court. You are hereby sentenced to an indeterminate term of imprisonment with a maximum of 4 years and a minimum of 1 1/3 years. I have a surcharge, crime victims fee, and DNA fee. They're all mandatory under the law. They total $375. They will be collected by the correctional authorities. As a result of your conviction for a felony, you lose your right to vote while you're serving the felony sentence in a correctional facility, but your right to vote will be restored upon your release. As a result of your willful disregard for the conditions of your release that I impose following the plea, I'm directing that the indeterminate sentences are to be served consecutively. You have the right to appeal from the judgments of conviction on the pleas you entered and the sentences I imposed. If you want to file that, you have to do so within 30 days of today's date. You can talk to Mr. Benjamin. The defendant is remanded to await transfer to the Department of Corrections and Community Supervision. You're all set. Thank you.